Court rise.
Yes, Mr. Guthrie.
My Lord, the first of the only a few matters which I wish to reply in respect of, I think your Lordships have already adverted to the point. My learned friend has referred to the Commission as not being a corporate body and not having a separate legal entity, but we submit there is nothing in that. The fact is, as he accepts, the Commission and the other commissions, which are not the four constitutional commissions, are regularly sued in their name in judicial review proceedings. And precisely the same difficulties so far as damages and costs might be thought to apply to such proceedings as he suggests apply to constitutional proceedings. There will be the possibility of a claim for damages in those judicial review proceedings. There will also be orders for costs to be made, but the proceedings it's accepted can be brought against the Commission in its own name.
And such orders for damages or costs would be met how?
Well that, I understand as a matter of practice they are likely to be met through the Attorney General, but that can't be a reason why one party is appropriate rather than another party.
I mean, is it the Attorney's submission that actually by suing a body such as this, you could wind up with an order that you couldn't then execute?
Oh, no, certainly not.
How would you execute it?
Well, my Lord, my understanding is, and indeed it was argued below, that the ultimate bill would be the taxpayers, so to speak. But it would not necessarily, as far as we are aware, not necessarily be paid by the Attorney General through his department. But, my Lord, I would simply repeat, really, that that should not be the consideration of who is the right defendant to sue. But I've no reason to quarrel with my learned friend saying that very often such proceedings are dealt with by lawyers from the Crown Office or the equivalent of the Crown Office. But that doesn't answer the points which we have made, and it doesn't answer the comparison with judicial review proceedings, which we say are regularly and can be brought against the commissions in their own name, and they are indeed the proper defendant and not the state, where an allegation is made of discrimination such as in the present case.
I'm sorry, I mean, assume you're one of the four stipulated service commissions. If proceedings are taken against you under Section 14 of the Constitution, well then I think we all agree you sue the attorney. I mean, you bring proceedings against the attorney.
Yes, as a result of...
As a result of the deeming provision.
Yes, indeed.
If you want to judicially review one of them, what's the position there?
You judicially review them under their own name, as I understand it. But certainly judicial review proceedings do take place, which I think I understand to be the position where the commissions are themselves defendants, named as defendants. But they aren't, of course, called by the constitutional. They aren't constitutional proceedings.
But do you accept they don't have legal personality? They could not employ as a body.
Well, no, I'm afraid I don't accept that. I don't know whether that's the position. I understand that they have staff as well, but I'm afraid I'm not sufficiently au fait with the internal workings of the civil service. But my submission is it's not a question which goes to whether they are the right defendants whether the SASC is the right defendant for constitutional proceedings in the present case. Lord, as for the deeming provisions, we have attempted to get a copy of the case of recent Crane, which is said to be behind the amendment.
As you speak.
It was a little more difficult than it used to be in the old days, because I understand the library is now more or less off limits, other than by a formal application by the lawyers in the case. So we've managed to either get one faxed through or... Lord, I'm afraid I haven't looked at it yet myself, so I'm afraid we'll do it at the same time.
Is there not a set of reports in the...
I'm sorry?
Is there not a set of reports in the...
There is a set of reports.
Lawyer's suite, as it's called.
Not including...
Not including appeal cases.
You say. There are some books in there, but I was...
They belong to the faculty of advocates, and I thought that they had this.
Well, we'll just have to make up our minds to bring everything just in case, I think. You'll see, my lords, this was a case brought by a judge. Lord, it appears, I think Mr. Ramlogan told you it was a judicial review, but it appears between letters D and E of the head note on the second page that he commenced proceedings, the judge commenced proceedings against the appellants who were the 3 members of the tribunal, the Chief Justice, and the other 4 members of the Commission, and the Attorney General of Trinidad and Tobago, seeking judicial review and redress for alleged infringements of his constitutional rights. Lord, I would make a principal submission that it isn't a very great assistance to speculate as to whether the deeming provisions were put into place for one reason or a combination of reasons or another reason. They are there.
So the deeming provisions followed from this?
Well, my lord, so we're told, but it is...
I mean, do we not know whether they were enforced at this time or not?
Well, they were after it. They were in 1998. But what I think... I mean, there's a reference in the argument, which I took you to at page 188, where it was suggested by us that the deeming provisions were a reaction to the decision in this case. But I'm afraid I can't really say more about it than that. And indeed, what does seem certain is that they were intended as rather more than a reaction to this particular case, because they don't simply apply to the Judicial and Legal Services Commission. They apply to the constitutional commissions as defined in section 3 of the Constitution, but not to any of the additional commissions which you've been told about, including the respondent in the present case, the SASC, but also to such commissions as the Salaries Review Commission, which Sir Fenton told you about. So it appears that a decision was taken to require proceedings, constitutional proceedings against the commissions to be brought against the state, but no more than that.
Sorry, I haven't followed the full impact. You say that section 98 applies to...
No. Section 19(8) under divider 7 applies. Sorry, this is the
Only to section 3.
Only to the section 3 commission.
Sorry, what were you saying was the position about the other one?
Section 3 applies only to those commissions.
Yes.
It defines,
Yeah.
but we know that there are other commissions, including the present commission, which
Yes.
are not,
Quite.
were not included in the deeming provision, although the deeming provision itself was wider than solely the commission with which Rees and Crane was concerned. So we are left with that, and I would respectfully submit that it's not particularly helpful to speculate as to the reasons why the deeming provision was in one form rather than another, or indeed to speculate, as I think was done by my learned friend, that perhaps it was rushed through and didn't refer to everything that it might have done. The fact is, it is there, and it would seem to follow from it that
I mean, when these amendments to section 19 were made, all these other bodies, including the one we're concerned with, were already in being.
yes, yes.
It's quite interesting. Now we see these proceedings, we see that they were brought against the Chief Justice as chairman of the Judicial and Legal Service Commission and against 4 other members of the Commission. They were also brought against the members of the tribunal.
Yeah.
But the only immunity granted in section 19.8 is in respect to
Yeah.
the members of the Commission. The members of the tribunal wouldn't have immunity. They might have judicial immunity.
Well, they might do. I'm afraid I. Well, from what we're told, it was certainly considered by some people that they didn't, because we're told that that was the reason for the amendment. But,
Well, I know, but I mean,
but the amendment wouldn't have been effective to that.
well, we were told it's the reason, but it may not have been. I mean, it may have been that the amendment deals with the position of those who wouldn't have the immunity. Where are the orders about costs? It's just the appellants must pay the respondent's costs. So it doesn't look as if any judicial immunity was claimed.
Well, Lord, presumably, the matter may have only arisen when an attempt was made to enforce the order.
But it does seem that the Attorney General was one of the appellants, so he was
yes.
party throughout.
Yes,
He was
yes,
there to put something.
yes, indeed.
Yes.
Yes. What
Well,
was the establishment?
Well, Lord, I, with respect, don't accept that it establishes very much at all. But, Lord, since it was raised, I've obtained it and put it before your lordships. But the fact is, the deeming provisions are there in the terms in which they are there, and we say that they plainly contemplate proceedings being brought against other parties who are not deemed to be the state. And those other parties, we say, can include the Statutory Authority Services Commission, the respondent in the present case.
Mr. Guthrie, I'm just looking at it. Is this a provision for removal rather like we came across in connection with Gibraltar?
Yeah.
I mean, so the actual removing body would be the body to advise on, finally to advise on removal was this board, and it was proceeding on the basis of a report by.
An ad hoc tribunal.
That's what I can't quite make out.
I mean, it seems to me the identical situation to that we have in Gibraltar. I mean, if you look between C and D, he appointed a tribunal to inquire into the matter, report on the facts, and recommend to him whether he should refer the question of removal from office to the Judicial Committee. That's exactly the position in Gibraltar.
Was this an ad hoc? Was it, or President shall appoint?
What did the statute require? Can't remember.
It's quoted at page 184.
The head note reads that the President appointed a tribunal to inquire in the matter and report pursuant to section 1737 subsection 3 of the Constitution.
Shall inquire. did the Commission come in at all?
I think it'll be exactly the same provisions.
It's on page,
I just on the head note, I mean, it seems to be the same scheme.
you see it at page 137, it's on page 184. Where does it?
Yes, it's, the statutory scheme is page 184, isn't it? That's F.
Yes.
The tribunal inquires and reports to the President and recommends to the President whether he should refer the question of removal to the Privy Council.
Oh,
But no claim could have been brought against the tribunal as a separate body. It was brought against the individual members of it.
Wait a minute, is Judicial Committee Privy Council or is it some domestic Judicial Committee?
it's Privy Council.
It is Privy Council, yes. Must be.
But those weren't, as I understand it, they weren't section 14. That was a judicial review tax. Is there any reference to a section 14?
Well, my lord,
Looks to me exclusively
between,
judicial review.
183D, my other friend helpful and told me.
Sorry, 183?
The ninth appellant, the Attorney General, this is in Lord Slynn's introduction, so to speak,
Constitutional motion.
is joined in particular to answer the claims made under the constitutional
Constitutional.
motion.
Sorry, letter what?
Constitutional D, 183D.
But one perhaps makes the observation in passing that something which is complained about in relation to exercise of the judicial arm of the state is a long way from what we are dealing with in present circumstances. '88.
Yeah,
Whether section 5.2 is relevant.
yeah.
A claim under the constitutional motion and on the application of judicial review, so thus in substance raise the same issue. It says. I'm asked to read that.
So is there any discussion in this case of our point, I mean, of what 19.2 meant before the amendments, before 8 and 9 were introduced by amendment?
Oh, Lord, I'm afraid...
No, I'm sorry, I
As
know.
you are.
I know, I merely... in case anybody else would like to...
Lord, I would come back to the point, as I think raised in argument with no friendly, how we say the SASC simply is not the state and cannot be understood to be the state, so that the section 19.2 doesn't come into it, because it doesn't help you identify who the state is, and since it's not the state, then the proceedings should not be brought against the Attorney General. The deeming provisions are, in our respectful submission, simply have to be seen as what they say. The only persons who it is required to, so to speak, adopt the legal procedure against the state of concern are the constitutional commissions which are defined by Section 3 of the Constitution and referred to by Section
I absolutely
19.
see the force. I mean, what's the logical reason for treating these 4 service commissions differently from our commissions or our...
Oh, Lord, we suggested in the case that they were more aptly to be considered as core public authorities than, for example, the SASC or perhaps the Salaries Review Commission, one could add that. And you'll recall that we did refer in our written case, although your Lordship said you didn't find it particularly helpful, to the Aston Cantley case, in which a distinction was drawn in this jurisdiction between a core public authority and a less than core public authority, which may or may not be exercising public functions. But the fact is, the deeming provision does not include the SASC. And one also has the what we submit is absolutely clear point that constitutional proceedings do not have to be brought against the state, as the Court of Appeal plainly thought that they did. And that comes from Section 13 of the Supreme Court Act, for example, which says that if there is a constitutional claim, it has in effect to be notified to the Attorney General in case he wants to deal with the matter, as indeed that is what happened in the Portal Authority case, you remember, the Boxville case. But the scheme does not require the Attorney General to be a defendant to all constitutional proceedings, and we say this is plainly one such, where he is not required. My Lord, I also wanted to, so to speak, take up Lord Walker's observation that one might need to look a little further at the cases of Gary and that line of authority, which I only referred to fairly briefly in opening. Lord, I think, with respect, that Gary does not take us very much further, but perhaps there is one passage in it which your Lordships have not yet seen, which it might be helpful for you to see. At paragraph 13 under divider 17, the Crown Proceedings Act in Grenada is referred to.
Sorry, what paragraph?
Paragraph 13 under divider 17. There's a subheading there. The Crown Proceedings took effect in 1959, closely modelled on the United Kingdom Act. Although with obvious differences, its object was the same, to remove certain historical impediments to bringing of civil proceedings against the Crown. Section 17 reproduces Section 21 of the UK Act. Section 21 of the Grenada Act, relied on by the Chief Justice Act, etc., is in these terms, and then there are similar provisions. Well, the provisions are there set out. If I take you to the other side of the page, just above paragraph 14, you'll see it said, the Act does not, like Section 38(2) of the UK Act, define civil proceedings as not including proceedings on the Crown side of the King's Bench Division. But the Chief Justice saw no reason why the expression should be understood differently in the Grenada statute, and this view has not been challenged. Well, your Lordships will recall that in the Trinidad statute, they are specifically excluded in the definition section 2 of the State Liability and Proceedings Act in similar terms to the UK Act. That's divider 7, subsection 2, section 2 of the Act. Civil proceedings includes proceedings in the High Court of Justice or a petty civil court for the recovery of fines or penalties, but does not include proceedings analogous to proceedings on the state side of the Queen's Bench Division in England. So,
how does that help?
my Lord, I don't believe that Gary does help very much, but my Lord, it is civil proceedings plainly don't include judicial review proceedings,
which could have been brought before before the Crown Proceedings Act was passed. Presumably, be it before the memory of any of us. There was no need for the Crown Proceedings Act to enable judicial review proceedings.
Yes. Oh, Lord, I think my Lord has specifically raised the question of what is 14 the tree therefore.
Yes.
Lord, it is dealt with in more detail than your Lordships have yet seen in the Durity case, which is under divider 18. Which is a decision of the board, the judgment being given by Lord Nichols. It was a case in which I was unsuccessfully attempting to persuade the board that various limitation provisions applied to constitutional proceedings because they were part and parcel of the State Liability and Proceedings Act. And I lost. The relevant passages begin really at page 18. And I think, my Lord, Sir Fenton did submit to you that the Section 14.3 imported the State Liability and Proceedings Act wholesale into the constitutional proceedings provisions. That would not appear to be right in our submission on this authority. But if I begin at page 18,
Page 18, we have
paragraph 18, I'm sorry, under divider 18. The State Liability and Proceedings Act, originally known as the Crown Liability and Proceedings Act, was modelled closely on the United Kingdom Crown Proceedings Act. Purpose was broadly similar. Primarily, its purpose was to modernise the law in two related fields, the substantive law relating to civil liberties and the rights of the state, and the procedural law relating to bringing civil proceedings by and against the state. Thus, as a matter of substantive law, claims formerly brought against the state with a fiat of precedent in future could be enforced as of right. These claims consisted principally of claims relating to land or goods in the hands of the Crown and claims for payments due under contract or for damages for breach of contract. Again, and this was a radical change in the law, in prescribed respects, the state was to become subject to the same liabilities in tort as those to which it would be subject if it were an individual. Section 4. As a matter of procedural law, ancient forms of proceedings, etc., were abolished. And if one goes to paragraph 23, I had argued that the State Liability Proceedings Act imported a particular limitation provision. Their Lordships have no hesitation in rejecting the Attorney General's argument on this point. The question before the Board is whether, on a proper interpretation of Section 14 of the Constitution, the incorporation of the State Liability and Proceedings Act into the Constitution by Section 14, subsection 3, shall have effect for the purpose of any proceedings under this section, has the effect of rendering constitutional proceedings subject to the limitation provisions of Section 2.1 of the Public Authorities Protection Act. On this, the first point to note is that the express but general reference to the State Liability and Proceedings Act in Section 14.3 cannot be read as meaning that every provision of that Act is incorporated into the Constitution for the purpose of constitutional proceedings. On even a cursory reading of the State Liability and Proceedings Act, it is at once apparent that some of its provisions can have no application to constitutional proceedings. They are not apposite. For instance, the changes in substantive law already mentioned, made by the State Liability and Proceedings Act, have no direct relevance to constitutional proceedings brought to enforce Chapter 1 rights and freedoms. Thus, Section 14.3 of the Constitution has to be read as applying as constitutional proceedings such of the provisions of the State Liability and Proceedings Act as are capable of being applied for this purpose. This gives rise to no difficulty with some of the provisions. Some, at least, of the procedural changes can and do have a place in the conduct of constitutional proceedings. This is most obviously so regarding the remedial powers conferred upon the High Court by Section 14.2. These remedial powers are qualified by the provisions of the State Liability and Proceedings Act. Section 42 expressly so provides by its use of the phrase subject to subsection 3. This qualification on the court's powers of granting redress readily finds explanation in Section 22 of the State Liability and Proceedings Act, which limits the power of the court to grant injunctions and certain other forms of relief in proceedings against the state. In such instances, the remedy available against the state is a declaratory order. The effect of Section 14 of the Constitution and its incorporation of the State Liability and Proceedings Act for the purpose of constitutional proceedings is that in constitutional proceedings there is a like limitation on the court's remedial powers. The context permits this application of Section 22 in constitutional proceedings. On the present appeal, it's not necessary to attempt to identify one by one the provisions which have scope for application and those which do not. For purposes of the present appeal, it's sufficient to state that their Lordships consider the crucial provision in Section 33 can have no place in the conduct of such proceedings. Their reasons are as follows, and those are then set out.
I'm afraid you've lost me. I don't understand why this helps.
Well, my Lord, it is an answer to my learned friend's submission that the whole of the Act is, so to speak, incorporated into the Constitution.
Why do they need the whole of it incorporated in the Constitution?
Well, my Lord,
I mean, all this, I understand the argument to be simply, look at 14.3.
Yes.
Inevitably, that means that 19 applies.
Yeah.
Under 19, if the proceedings are here against the state, if that's the proper view of them, well, then the attorney's your only target.
Yes. Well, that's exactly so. And we say that the Section 19 doesn't help in the crucial question of identifying who is the state. We say the state is plainly not the Statutory Authority Services Commission, and there is no reason to say that it is. And the various reasons which are advanced by our friends seem to be largely couched in for practical considerations on damages and costs and so forth, but don't go to the issue of whether or not the Court of Appeal was right in simply assuming that constitutional proceedings all have to be brought against the state on the basis of Section 14.3.
Would you agree, Mr. Guthrie, that one of the difficulties about this part of the case, which may not ultimately be all that relevant, but one of the difficulties in understanding these cases is that there's the constitutional motion and there's judicial review. And in some of the cases, like recent Crane, we find the Privy Council saying basically that they're the same issue.
Yeah.
But in other cases, we find the Privy Council saying you shouldn't use a constitutional motion if you can go by ordinary judicial review. And then again we find that it seems, once you unpick Section 19 and Section 25.2 and so on, that you may actually find you need different parties for a constitutional motion and judicial review. Is that part of it?
You may do, in that there may be matters which you could bring in, so to speak, using both streams, which would require you to bring the Attorney General in because it was indeed an action against the state. In other words, you could judicially review a commission, but you would have to bring the Attorney General in as an extra party. But if the Attorney General is not, if you're not bringing an action which is properly registered against the state, then you don't, and indeed we respect to submit that you shouldn't. My learned friend Praise says he wants a certain situation so far as the man in the street is concerned, or as he puts it, the man in the maxi taxi in Port of Spain. But we have, so to speak, an equivalent cross-complaint that the way things are couched according to the Court of Appeals judgment, because the man in the maxi taxi in Port of Spain is going to think that every time his constitutional rights are breached, it's the state's fault, which we submit it isn't. And this is an example of a situation in which there was nothing, the proper defendant from the point of view of investigating the complaints of Mrs. Smith was the SASC. They should have been joined. There was no reason why they should not have been joined. And this is not properly seen as an action against the state at all. My Lord, sir.
Is the National Lotteries Board, is it not carrying out a sort of state function?
Well, my Lord, no more than the Port Authority is.
Well, a little bit more, because the balance of the revenues is paid in the end of the day under Section 23 to the Consolidated Fund.
Well, my Lord, that would be true of any public function, but it's not a state. One shouldn't confuse something which is a public function with something which is performed by the state.
Well, I presume it's a state monopoly.
Well, my Lord, I don't believe there are competing monopolies, but
they set up this national. How does one say that dismissing people and so on from the National Lotteries Board, running of the National Lottery and so on, is not a sort of state function?
Well,
it is one, but you say not a
core
core
one.
one.
It's really a question of linguistics. The question is whether or not this commission is the state or it isn't the state.
Yeah,
if it isn't the state, then it shouldn't be sued. The Attorney General shouldn't be the party. And we say, looking at the statutory framework, which I've taken your lordships to, there is no reason to hold that it must be brought against him.
I don't think Mr. Gladstone would have thought that running a lottery was a core state function.
Well, my Lord...
Mr. Gladstone had healthier finances.
Well, I seem to remember that Mr. Gladstone's occupations were many and varied. So, well, there's well, I think your lordships really see the point. My lords, on the question of costs, depending on which way it goes, might I invite your lordships to make an order providing for written submissions to be put in within a reasonable time? I simply may need to take instructions, and also it seems to me there are a variety of possible ways of approaching it. So,
So one last throwback. I mean, if you want to bring Section 14 proceedings against the Cabinet,
Lord, I have a feeling that the Constitution refers to the Cabinet as being responsible to Parliament, does it not? I don't know whether one could judicially review the Cabinet either.
sorry?
I don't know whether one could judicially review the Cabinet either.
Where's the Cabinet dealt with it?
But I suppose if I'm going to use the language
in
of
the
core government
executive,
functions, it might include the Cabinet.
The cabinet isn't a statutory concept, is it? Or is it?
It is.
Yes,
It
75.
is established by the Constitution.
In this
What section?
Section 75, there shall be a cabinet.
Yes.
Yes.
It's in that bit about the executive that you find the bit about section 76 too.
The basis upon which these proceedings were brought would seem to be fit in very well with the constitutional right which is alleged being framed, which is unequal treatment by a public authority, which is exactly what this lady is complaining of. I would submit, suggest that she should simply have brought the proceedings against the public authority concerned. And there was no reason why that was wrong. Much of the territory or lordships that are covered was not in fact the subject of the Court of Appeal's consideration. They appear to have thought, which we submit must be wrong, that any constitutional motion under any circumstances must be brought against the Attorney General. But that would appear to go against the whole statutory structure which I've shown you, and also the cases which the board have decided in the past, such as Maharaj and Thornhill. But, my lords, I'd say what I...
Their lordships are grateful to counsel for
My
that.
Lord, before my
You
Lord,
want to?
can we say something about that reason, Crane?
Yes, you may. It's,
Very obliged, my lord. My lords, might we start on a small note of correction, and it has to do with the genesis of the amendment and the deeming provisions. And I'd like to remind my lords, at page 188 of the record, that this is in fact a matter of agreement between the parties from day one. This is how the deeming provision amendment came into play. It was introduced by the state in their written arguments at page 188. And this is what the state had submitted. It submitted that it is paragraph 6 on page 188 of the record. It is respectfully submitted that this honourable court can take judicial notice of the fact that it was passed in response to the threat by the applicant, respondent, and reason Crane to levy on members of the JLSC for his costs after he had succeeded in judicial review proceedings against them. It is meant as an indemnity provision and does not say where there is a cause of action against the Service Commission, the applicant may choose to sue the state instead. Now, I had conducted the case in the High Court and in fact agreed with that position, so that the case has been conducted in the local courts on the basis that this is in fact what led to the amendment and the deeming provision. It was not to make the service commissions a part of the state. It was simply from the angle and the lens through which we must view it is really the question of indemnification. I mean, one may very well argue that by not including the Statutory Authority Service Commission, it was felt not necessary because it was obvious that it's part of the state. There was no need to include the Statutory Authority Service Commission because it was fairly obvious it's part of the state because it wasn't a constitutional service commission, perhaps. I don't know, but I posit that hypothetically. The second thing, my lord, is in reason crane. If my learned friend is correct, if we look at the reason crane judgment and we look at page 183, paragraph D, Mr. Crane was claiming a violation of his constitutional right to protection of the law, and he had in fact already sued the members of the Judicial and Legal Services Commission. If my learned friend is correct, then there would have been no need to sue the Attorney General for the violation of his constitutional right. The proper party, this was before the amendment and the deeming provision. And if Mr. Crane wanted to claim a violation of his constitutional right prior to the amendment, then he ought properly to have been able to sue the Judicial and Legal Services Commission in its own name and right. But as we can see from paragraph D, the 9th appellant, the Attorney General of Trinidad and Tobago, is joined in particular to answer the claims made under the constitutional motion. So you had the Service Commission, but yet still, when it came to the constitutional motion, the proper defendant had to be the Attorney General of Trinidad and Tobago. And as we see at F, on the constitutional motion, the first appellants were prohibited, damages be assessed, etc. In any event, there was no huge discussion on the matter in this case, as has happened in this instant appeal. But there is one judgment of this board, which unfortunately, due to a lack of facilities, we have not been able to pull. But it's a case of Vinud Jagru versus the Teaching Service Commission, V-I-N-O-D-E, Jagru, J-H-A-G-R-O-O, versus the Teaching Service Commission from Trinidad and Tobago. It was a judicial review against the Teaching Service Commission brought by a teacher, and the appeal was allowed by the board, and it awarded damages for the retroactive loss of salary. I'm afraid I don't remember the year offhand, my lord, but I can supply a copy, by the end of today through my solicitors. But the important point is, because damages were awarded, the state in that matter requested, it was a judicial review, and the state requested, in light of the committee's decision to award damages, that the Attorney General be made a party to the proceedings to facilitate the payment of damages. It's in the last paragraph of the judgment, and it's often cited by myself in the local courts to ensure that people can be paid without having to undergo the hassle and the embarrassment of having to levy on people who are just, appointed to serve in public office. So, my lord, we don't think reason crane really takes the matter very much further, except that it confirms that when the constitutional motion is issued, the proper defendant, even if you had the substantive commission, had to be the Attorney General.
On your analysis, the Teaching Services Commission should never have been sued at all.
Well, that was a judicial review, yes. The answer is they ought to have been sued. But the point is, once damages were awarded, because it's recognized by the state that the Commission does not have a budget of its own to pay the damages, and that was a judicial review matter, you will see that what happened before the Judicial Committee is that the Attorney General was added as a party at that stage of the proceedings, simply to facilitate the payment of the damages. And finally, my lord, the case cited by my learned friend at tab 23, even if we are wrong on all of this, the St. Lucian case from the Court of Appeal, you will see that even if we are wrong on all of this, the correct approach as adopted by that court in St. Lucia, where they claimed the violation of the constitutional right to personal liberty and protection from the deprivation of property, was not just to sue the Controller of Customs, but also the Attorney General. So, which was my fallback position in the High Court from day one. Don't strike out the Attorney General. Under no circumstance could he have not been a party to this action. You can join the SASC if you so desire, if you feel it's necessary, but you couldn't possibly strike out the Attorney General. He was and remains a proper party to this action. I'm obliged.
Their lordships are still grateful to counsel and will take time to consider their judgment.